Guys, what's up? So we will be dealing with polity again after restarting after prolonged demand made by you. So here we go because the popular vote will win. So I have started the directive principles of state policy. Before I have made 1.1 to 1.4, which covers the basics, the preamble, the schedules of Constitution of India. Then we started from part 2, which dealt with the citizenship, and then we started with part 3.1 to part 3.4, which dealt with fundamental rights. So total 10 videos are already there on polity, so I suggest you watch them before. देखने से पहले वो देख लेना भाई, तभी कुछ थोड़ा ज़्यादा समझ में आ जाएगा. This is the 11th video in the series, that is a DPSP. And if you have any doubt or any query, like most of you suggested me to start the polity series back again, that is why it has been started. There is absolutely no other reason. So you just comment below the YouTube or on the Facebook page, and rest assured I will look after them and they will be included in the next video. So we start with directive principles of state policy. This video is so crucial. You have absolutely no clue how crucial it is for your examination. One question directly will come from this video, absolutely guaranteed, either in prelims or mains. The thing is, I will explain it so lucidly, you will forget about everything else which you have ever been learning. Absolute everything will be covered. So some basics about this DPSP. It comes from the part 4 of the Constitution. Obviously, we have done with part 1, India, that is Bharat shall be Union of State, Article 1 to 4. Then 5 to 11 deals with citizenship of India. 12 to 35 deals with fundamental rights, and 36 to 51, that is part 4 of the Constitution, deals with DPSP. And it has been adopted from an Irish Constitution of 1937, which indeed adopted it from Spanish Constitution. So whenever question comes, we have adopted it from Irish Constitution DPSP portion. What is the basic feature? The state should keep them in mind. हमेशा ये दिमाग में रहना चाहिए. Whenever you are making laws or you are enacting any policy, these should be in the back of your mind. These should be like the guiding light. These just like the lighthouse when the ships needs to be guided. So they are like the guiding light at the end of the tunnel. And even though they are non-justiciable in nature, yet they are extremely crucial. I'll just let you know how. So first of all, the technical stuff. The term state in part 4 and part 3 are absolutely same. So if we go to the article 12, article 13, they describe what is law, what is state. Then only it starts with the fundamental right, that is 14, that is equality before law. So 12, 13, they describe what is law, what is state. So the same meaning of state which is there in part 3, that is fundamental rights, is there in part 4. That is legislative and executive branches of both the government, that is central government, state government, all the local authorities, all other governments, any orders, bylaws passed will be covered in law. And here the state will be any public authority. Absolutely any public authority is a state. And it is somewhat similar to instrument of instructions, which was used way back about 80 years in Government of India Act of 1935, according to Dr. B.R. Ambedkar, the father of our constitution. And Article 37 reveals that. What does it reveal? The directive principles are not justiciable at all. That is, they are not legally enforceable in court of law. So if you are violating them, let's say Article 44 says that uniform civil code should be there in India, but if it's not there, you can't go to court running that why it is not there and it has been violated. So it is not like that. So, but what is the good point? It sets the agenda for economic, social and the political program for a modern democratic state. So all this agenda sets an objective, which means that we have to come as close as possible to achieving the ideals of justice, liberty, equality and fraternity, which are enshrined in the preamble of the Constitution. Then we have to put the faith that it is a welfare state we are making and not a police state. And finally, in short, there are positive obligations which states has to take into account by formulating policies and laws which will help them in action. So why DPSP are non-justiciable? This is a very critical question which our founding fathers obviously asked to themselves, and then in their all wisdom they made two kind of rights: fundamental rights which is justiciable, and DPSP which is non-justiciable. If you know, Sir Rao was there. He was the constitutional advisor to Constituent Assembly. So he said that there are not enough financial resources for the state to implement them. As you can see, it has lots of hefty goals. Let's say one was that provide free education to 6 to 14 years. अगर ये 1947 में हो जाता, the state did not have any resources to do it. It was impossible virtually for us to make this into fundamental right. But now it is a fundamental right. So we take care of early education, that is less than 6. So this is how state will progress. So because of the vast diversity and backwardness, it will deter their implementation. Obviously, there are lots of factions which will prevent the implementation of many DPSPs. And finally, their newly independent Indian state had just too many things on their plate to worry about. So the state should be free to decide the order, the time, the place, and mode of implementing DPSP. If you know, the right to education made a fundamental right in 2002, but it came as an act in 2009-10. So that is the time it takes, almost about 60 years after independence. So state should have the flexibility to implement them. That is why it is non-justiciable. But what is the point of it if it's non-justiciable, right? This is the second question which comes in your head, right? Although there is no compulsion for implementation, वो तो बात सही है आपकी, there is absolutely no compulsion on state to implement them, only from the judiciary side. This is the key point. But जो political compulsion comes from the popular electorate, according to Dr. B.R. Ambedkar. Hence, they are absolutely fundamental in the governance of the country. This is the language of Article 37, and it plays a extremely crucial role in conclusion by courts. Courts determine and tell whether a law is constitutionally valid or not in the light of DPSPs. What is the present situation? The present situation is that Supreme Court can, I am telling, can overrule Article 14, that is equality before law, and Article 19, which contains 7 freedom. Earlier, now it contains 6 because right to property has been gone. If a law wants to give effect to DPSP, is that absolutely understood? This is the present situation. So DPSP has slightly upper hand over fundamental rights. And finally, it shall be the duty of state to apply these directive principles while it's formulating policies or making laws for the governance of the state. That is why they are non-justiciable yet extremely important. This is a question very frequently asked. So these are the three statements which you should be reading. Dr. B.R. Ambedkar said that a government which rests on popular vote can hardly ignore the directive principles while shaping its policy. Extremely important statement. And if any government ignores them, it will certainly, and I am telling it will certainly have to answer for that before the electorate at the time of election. Similarly, Alladi Krishna Swami Iyer said that no ministry responsible to the people can afford lightheartedly to ignore the provisions in part 4 of the constitution. And finally, unanimous voice of constituent assembly, that is article 37, it reads, and I quote, these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So is that absolutely understood? Now what is the position of DPSP? So our founding fathers took a middle path. They took a pragmatic issue which has a maximum probability of success. That is pragmatic. It's not very ideal, it's not very impractical, it is pragmatic. And it's dependent, the implementation of DPSP is dependent more on people's will rather than court procedures. The ultimate test of DPSP is the people's will. What is the evolution of DPSP? How did they came about? So Kautilya way back in Arthashastra wrote that king is like father. King is like father figure. I can quote the Sanskrit Doha, but most of you will not understand it. Anyway, so responsibility of the king is to the people of his kingdom. King is the father, and the praja is their son. That is, people are their son, are his son. So he has to do something to enable their life in a better way. So he propounded something called as civil, economic, and social rights. And further, in British period, there was lots of economic exploitation. We were deprived of social rights and political freedom. Hence, we gave to ourselves the social justice. If we read the preamble, it is we the people of India on this 26th November 1949 do adopt, enact, and give to ourselves this constitution. So we gave ourselves the social justice, and this epitomizes the ideals of the people of India, obviously, and evolved along the emergence of constitutional form of government. So now, what do you mean by constitutionalism? They are very fundamental questions. So constitutionalism is that it's given by the theory of Locke, if you read philosophy, that government can and should be legally limited. This is very important. Government cannot be asked to become a leviathan, that is a monster, a beast which has all superpowers in it, and that the authority or legitimacy depends on its observing these limitations. So government should observe this limitation, and then only it can be deriving its legitimate authority. Now what do you mean by welfare state? State exists for welfare of people, as simple as that. And this is grounded in a set of inalienable rights of the individuals, which are called as human rights, HRs, not human resource. So they are the form of social and economic rights. Always remember socio-economic rights. DPSP are socio-economic rights. Socio-economic rights, and state should extend them by exacting necessary laws. They are just like a form of instruction or direction to the state, and they are unique blend of principles of socialism. This will deal in next video. Gandhism, Western liberalism, and ideals of freedom struggle of India. So they are the four categories in which I'll put. One is there for international peace also, but that is more or less covered in Western liberalism. Finally, it seeks to promote a comprehensive socio-economic and administrative structure for a modern democratic state. So if you write these lines, you'll get extremely good marks, and if you understand them, you will not do any MCQ wrong. Now this is extremely critical table, contrast between fundamental rights and directive principles of state policy. So I'll just go through it fast. Fundamental rights is negative in nature, that is, it prohibits a state to do something. State shall not do this. No, there should be no untouchability. There should not be begar. There should not be forced labor. There should not be exploitation. State should not interfere in religion. Something like that. State, no person will be discriminated from entry into villages on the basis of race, religion, caste, sex, birthplace of birth, etc. So it's all negative sense. State shall not do this. State shall not arrest. There should not be double jeopardy. Can you get the sense? While positive, state shall provide free education. State shall strive to provide jobs. State shall strive to provide this, that, enabling environment, etc., etc. So they are positive in nature, and they require state to do something. Is that absolutely understood? Then they are obviously justiciable, that is legally enforceable in law. In case they are violated, they are non-justiciable and not legally enforceable. Their objective is to establish political democracy. If individual needs to have certain basic rights to exercise their vote and participate healthily in the politics, and their objective is to establish socio-economic democracy, and they have legal sanctions obviously, and there is absolutely no need of legislation for implementation. But here the legislation are needed because there are only moral and political sanctions. So for example, right to education, MJ and REGS, all needs to come for this to be effective. Now it is individualistic based, it is community based or society based, and if there is any law which is in violation of fundamental rights, Supreme Court is bound, and I repeat, Supreme Court is bound to declare it null and void, while there is absolutely no such binding on DPSP. Rather, Supreme Court can enable certain rights just to give effect to DPSP. So this is the contrast between fundamental rights and directive principles of state policy. Now, what is the relationship between fundamental rights and DPSP? So first of all, Granville Austin, obviously I will quote him. It's a very huge political critique on Indian Constitution. So he says that it is the conscience of the Constitution, this part 3 and part 4. Some say it is the soul of Constitution, some say it is the basic philosophy of the Constitution, some say it is the heart of the Constitution, some say it's cornerstone of the Constitution, part 3 plus 4 combined. So you can say whatever you want to, but remember these words, they are extremely critical. What is the purpose of this? Purpose is to fix certain goals which are socio-economic, and it will done by bringing non-violent social revolution in time. It will be gradual, but it will be done in time. Then Article 37, state needs to incorporate DPSP in the policies formulated by executive and the laws enacted by the legislature. And this is the key question which should be asked by each and every of you. Let's say if I want to give effect to certain DPSP, let's say Article 39 B and C, that state shall try to decrease the inequality. So for that, if I do, then Article 14 will be violated, that is right to equality before law. So there is a direct conflict between 39 B and C and Article 14, and then there are 6 freedoms under Article 19. And remember the pre 44th Amendment Act era where there was Article 31 also. तो अगर आप अपनी प्रॉपर्टी रिडिस्ट्रीब्यूट कर रहे हो अंडर लैंड सीलिंग एक्ट, सो आर्टिकल 31 is violated. So if there is a conflict, then what is the relationship between FR and DPSP? Who will rule who? This was the question which was asked in 1951, just 1 year after our constitution came into being. So it was asked in State of Madras versus Champakam Dorairajan case, AIR 1951. Supreme Court, Honorable Supreme Court held that DPSP are subordinate to the fundamental rights. And absolute clear language, they shall conform and run subsidiary to fundamental rights, and if there is any conflict between them, fundamental rights shall prevail over DPSP. So it was a very narrow interpretation, and many of the social legislation including the land reform acts were held to be unconstitutional by Supreme Court. तो इसके लिए फिर 9th शेड्यूल का आगमन किया गया था. That was the first constitutional amendment act under which land reform act were put, and they were beyond judicial review. Till date there are 243 acts in 9th schedule, and any act which is before 1973 cannot be undergone judicial review, but after that they can be. I'll tell you later, but anyway I have covered this in the schedule video 1.3 and 1.4, so please watch from there. So the up condition क्या है, fundamental right is far far superior than directive principle of state policy. This is the official stand. Now comes the Kerala Education Bill 1957 under Article 143 subclause 1. Do you know what is Article 143 subclause 1? If you know, good. If you don't, I'll tell you. Under this, President can ask Supreme Court for its opinion if legislation is of extreme importance and has huge repercussions and social consequences, and Supreme Court needs to give its opinion to President. So in determining the scope and ambit of the fundamental rights relied on by on behalf of any person or body, the court may not entirely ignore these DPSP laid down in Part 4 of the Constitution. It is so boring to read these lines if you don't make your own notes. It's extremely boring. You just can't do it. It's boring, plain simple. So what I'll do it, I'll make it easier for you to understand them. So just आप यहाँ पे focus करो, भूल जाओ उसको. So after realizing the growing importance of DPSP, भाई ये पता चलने लगा DPSP बहुत important है. Supreme Court gave a wider interpretation and changed its narrower interpretation to provision of Constitution in order to reconcile the fundamental right and DPSP as far as possible. अच्छी बात है भाई. So केरला एजुकेशन बिल 1957 केस में क्या हुआ, 3 पॉइंट थे, ये मैंने अलग से लिख दिए. देयर इज नो इनहेरेंट कन्फ्लिक्ट बिटवीन फंडामेंटल राइट एंड डीपीएसपी. भाई दोनों एक ही चीज़ तो करना चाहते हैं. दे वांट टू एम्पावर पीपल that together constitute an integrated scheme of establishing political, socio-economic democracy in the country. ये बात भी सही है भाई. Thus they are supplementary to each other and must be harmoniously constructed. ये एक टर्म यूज़ कर लिया इन्होंने, harmoniously constructed. बहुत अच्छी बात है. एक उसको आप पढ़ो जजमेंट को, then it takes you a lot of time and you don't remember anything. But if you do like this, it becomes very very easy and you retain and you can reproduce in the exam. That is the sole purpose why you are studying it. Then there is similar theory which was also given later, like 20 years later, in the Mumbai Kamgar Sabha case of 1976. So where there are two judicial choices available, two or more, the construction in conformity with the social philosophy of Part 4 has preference. सीधी सी बात है, जो भी construction होगा, जो भी harmony होगी, that needs to be taken care. So DPSP are like stairs to climb and to become a socialistic state where everyone has some basic rights which are inalienable, while fundamental rights are means to reach the टॉप. तो अभी सबसे पहले आप डीपीएस पे फोकस करो एंड यू कैन लेट गो ऑफ सम फंडामेंटल राइट. दिस इज द प्रेजेंट स्टैंड, बट आई एम टॉकिंग अबाउट 50 years बिफोर. तो सुप्रीम कोर्ट ऑल्सो प्रोपाउंडेड द थ्योरी ऑफ हार्मोनाइजेशन. अब देखो भाई ये थ्योरी ऑफ हार्मोनाइजेशन क्या चिड़िया है. सो लेट्स सी व्हाट इज थ्योरी ऑफ हार्मोनाइजेशन. सो इफ अ लॉ पास्ड बाय अ स्टेट which give effect to one or more DPSP, is that absolutely understood, and is capable of giving one or more interpretation, if one of the interpretation leads to the DPSP being in harmony with fundamental right. भाई एक तो तुम उसको harmoniously interpret कर रहे हो, so they are all together in one umbrella. एक तुम उसमें conflict create कर रहे हो, either this or that. So जो ये वाले interpretation है ना, that will be selected. The interpretation which shows them in harmonious light, they are conforming to each other, they are cooperating, they are collaborative, they are coordinating, that will be chosen. तो कोर्ट शैल प्रेफर द फर्स्ट प्रेफरेंस इंटरप्रिटेशन एंड इट विल वैलिडेट द लॉ. तो उस केस में दोनों हो जाएंगे ना, डीपीएसपी का भी नहीं कटेगा, फंडामेंटल राइट्स विल आल्सो बी देयर. सो दिस इज द रियल मैंडेट ऑफ द कॉन्स्टिट्यूशन. दिस इज द कॉन्स्टिट्यूशन वांट्स. कॉन्स्टिट्यूशन वांट्स हार्मोनी बिटवीन दीज टू पार्ट्स एज फाउंडेड बाय आवर फाउंडिंग फादर्स. दे वांटेड फंडामेंटल राइट्स एंड डीपीएसपी टू एग्जिस्ट टुगेदर, and this is limited not only to executive and legislature, but it is also complying of judiciary. So both L, E and J are equally compliant, should be equally compliant to this mandate. However, there might be a certain condition जब सिर्फ और सिर्फ only and only one interpretation is possible and that particular is not harmonious. It is leading to conflict between DPSP and FR. So if that is the case, court will have absolutely no choice but to implement the fundamental rights in reference to directive principles of state policy. So on the basis of above interpretation, Supreme Court held, what does it held? That Bank Nationalization Act as well as the Privy Purses Abolition Act is unconstitutional, null and void. Later both were deemed valid after केशवानंद भारती case in 1973. चलो अब इसको छोड़ो, अगले वीडियो में देखेंगे, अभी इतना सुन लो. सो नाउ जो फंडामेंटल राइट्स आर ऑल्दो सुपीरियर टू डीपीएसपी, बट थ्योरी ऑफ हार्मोनाइजेशन से एक वाला कम हो गया. सो नाउ देयर स्लाइट एडवांटेज, नॉट वेरी मच. दे हैव जस्ट स्लाइट एडवांटेज, नॉट वेरी मच. अब आता है गोलकनाथ केस. सो व्हाट हैपेंस इन गोलकनाथ केस ऑफ 1967? सुप्रीम कोर्ट रूल्ड दैट द पार्लियामेंट कैन नॉट, एंड आई एम रिपीटिंग, कैन नॉट take away or abridge any of the fundamental rights. The fundamental rights are sacrosanct. They are nobody can touch them now. They are sacrosanct in nature, so you just cannot amend them. And fundamental rights cannot be amended. Absolutely no amendment is allowed for the implementation of directive principles. So अब position क्या होगी? Fundamental rights are far more important and superior than DPSP. तो इस स्टेट में आपको छोड़ देता हूँ. सो इफ़ यू वांट मी टू मेक नेक्स्ट वीडियो ऑन दिस, लेट मी नो. सो दिस इज द यूट्यूब चैनल अन अकेडमी. यू कैन ऑल्सो ट्वीट टू मी एट माई ट्विटर हैंडल एट रोमन सैनी. डू स्प्रेड द वर्ड यार, थोड़ा बहुत बता दो लोगों को. दैट स्पेशली दोज हू कैन नॉट अफोर्ड कोचिंग कैन वॉच दीज वीडियोज़, एंड थोड़ा बहुत भला हो जाएगा. दैट्स ऑल आई कैन से. थैंक यू फॉर वॉचिंग द वीडियो. हैव एन ऑसम डे.